Okay, up at the top left-hand corner of your screens, you should see the YouTube icon, and that means we are successfully, again, publicizing this to a certain degree. We've got two motions, I think, pending. The first one is the motion for judgment notwithstanding the verdict, or in the alternative for a new trial. I think it makes sense to take them up with the motion notwithstanding first, and then the motion for attorney's fees, although chronologically they're filed a little different. So does anyone have an objection with the plaintiff going first?
No, Your Honor.
Okay. All right. Now, where's Mr. Clifford? Ms. Rogers, is this you?
Yes. So
I thought you withdrew.
Mr. Clifford withdrew.
Well,
because,
you know, maybe I should have read that a little more carefully. That's the kind of precision you can expect.
No, yes, Your Honor. Mr. Clifford withdrew because he was appointed as a federal judge, and so he
Get
can
out of here.
That's correct.
Is he inviting us to his investiture?
You know, I would imagine probably not. I think he would assume we wouldn't make the trip.
Okay, well, if you do ever get a chance to speak to him, please give him my congratulations. That is wonderful.
I sure will.
And he has certainly left the case in good hands. So, Ms. Rogers, if you'd like to proceed.
All right. Well, good morning, Your Honor. As you know, we are here today on our motion for judgment notwithstanding the verdict. And we move the court to enter judgment in favor of the plaintiff in the amount of the $68,870.81 plus attorney's fees and costs pursuant to OCGA 91150, because one, the defendant does not have any legal defense to the claim. Two, the defendant was improperly allowed to admit hearsay as evidence during the trial, which led to the defendant's verdict. And three, even if defendant's hearsay was true, it would still be a breach of contract because the agreement did not give Mr. Taylor the power or the authority to instruct defendant in the manner in which he allegedly directed the defendant to give away no charge product. The defendant was aware of this lack of authority based on the plain language of the applicable contracts and because of all of the invoices he received billing him for the product he was allegedly instructed to give away. While defendant has attempted to make this matter more complicated and confusing, it is a very simple, straightforward matter. Defendant testified that he read and signed the agreements that stated he would be provided a set of initial sample product and that anything else ordered by outside sales reps, including himself, would be sold, invoiced, and purchased by the outside sales rep, unless the outside sales rep returned the extra sample product that was ordered. If it was returned, then his account would have been credited for the original amount plus the 5% bonus, which Ms. Jackson noted was an extra incentive to get the outside sales reps to return the product. As we briefed in our motion, the agreements did not give management the authority to give away any non-charge product, and Ms. Jackson testified that none of the product for which we seek payment was no charge product. While during his employment and up to 14 days after termination, defendant had the option to return the no charge product for credit to his account. He did return some of the product for which he was invoiced, and there was no dispute that his account was properly accredited for those returns, as noted by Ms. Jackson's testimony and the credit memos that were produced during the trial as Exhibit 8. Likewise, the product his manager decided should stay in the field was also credited against defendant's outstanding balance. The product that was not returned or left in the field therefore remained on his invoices due. Over the years, he received invoices showing the charges for the product that the defendant had already given away. He never complained or contested one charge on any invoice until after he was terminated. And while the agreement does allow sales managers discretion to dispose of the sample product, it is only at termination. In spite of defendant's omission of that language, when citing the language regarding the discretion to dispose of the same by other means in Section 9D, which Ms. Jackson testified that other means is the practice in which sales managers may direct some of the product to stay in the field at termination, which was done in defendant's case. Again, that language that gives the sales manager the discretion is in 9D, and it's only at the point of termination. Here, that language is inapplicable because admittedly, defendant gave away the sample product at issue in this case before he was terminated, before Mr. Taylor would have had any discretion regarding the return or other disposition of the no charge product. Moreover, defendant does not claim that he was instructed to give away the product at termination. In defendant's response brief filed yesterday, defendant attempted to argue that since Callaway did not specifically tell defendant that Mr. Taylor could not give him direction, he had no notice of Mr. Taylor's lack of authority. However, this argument ignores the plain language of the contract that defendant acknowledges he read before signing and provides limited discretion to sales managers to dispose of product. Since the contract very specifically outlines the exceptions to the rules regarding when sales managers do have such discretion, defendant had actual notice and constructive notice that Mr. Taylor wasn't authorized to tell him to just give away the no charge product. With regards to the hearsay, all of the defendant's testimony based on OCGA 801D related to what Richard Taylor and other sales managers told him was hearsay because it was a statement made by someone other than the defendant, and it was offered for the purpose of proving the truth of the matter, that Mr. Richard Taylor or some other manager instructed defendant to give away the product. In spite of defendant's arguments to the contrary, defendant's testimony and defendant's counsel's arguments fail because Mr. Taylor's statements or any other manager statements do not constitute party admissions pursuant to OCGA 24880D2 C and D, because Mr. Taylor nor any other manager alleged to have given defendant the authority to give away the no charge sample product met the statutory requirements to be an admission against interest. In order to be an admission against interest, the statement must be by a person authorized by a party to make the statement concerning the subject. And as briefed and highlighted throughout the evidence at trial, no one was authorized to instruct the defendant to simply give away the no charge product while he was employed by Callaway. Moreover, it is required that the statement be by the party's agent be within the scope of the agency or employment made during the existence. And when looking at that, it's not just whether the statement alone was sufficient to determine the authority, but you also have to look at the scope under the employment relationship. And in this case, Mr. Taylor, nor any other manager of the defendant, which supposedly made these statements, would have had the authority to do so. And because they didn't have the authority to do so, it was beyond the scope of their employment. As noted in the Royal Oil case, where it is clear that the employee had no authority, apparent or otherwise, based on the plain language of the contract, in this case, his alleged statements were outside of the scope based on the plain language of the contracts that Mr. Taylor and Mr. Smith read and signed. With regards to the contract and the arguments that plaintiff raised, there are a couple of things that are important to note. Whether or not the 2018 contract was superseded really doesn't have any impact on whether or not the defendant owes for the 2018 or the 2019 invoices. As noted and testified during trial, and which defendant fails to acknowledge or explain, is that the 2018 invoices all state that they were not due until December 31st, 2019, such that any issues with non-payment of the 2018 invoices would not have been an issue until 2019, which is when the 2019 contract was in effect. Moreover, the 2019 invoices were not due at the time the defendant quit. When he quit on June 2nd, 2019, that is when the invoices were due. As such, all of the defendant's arguments that a Callaway is attempting to reap a windfall or never sought repayment are illogical, and they fail because the invoices were not due and they had no reason to ask Mr. Smith to pay the invoices because they had not come due at that point. Once the invoices were due, Per the contract, 14 days after his termination, Ms. Jackson testified that at that point, the plaintiff reconciled his account by crediting the defendant for what he did actually return in the amount of $58,857.89, as well as a credit for what Mr. Taylor instructed the defendant to leave in the field for the next outside sales rep. Those things were credited to his account, and that is when they sent the invoice for what was outstanding in the amount of the $68,000 and miscellaneous dollars and cents. Defendant also claims that Callaway never complained about the non-payment in 2018 and 2019 because they were not due. But they also attempt to say that he never had to reconcile and make it seem as if he never had to pay for any product before he left. And that is not true. Defendant testified that he had paid for some of the sample product he received. And he testified that some of the sample product was allegedly stolen from his home. As such, those credits and the testimony and assertions that his counts were never reconciled in any way are simply untrue. Moreover, Callaway never asked any sales rep to return any product because, as the contract states, it is understood that you either return it or you buy it. So they don't demand that the employees return the product. They have a choice. They can keep it if they like, but if they choose to keep it, they have to buy it. At no point has defendant ever stated or testified he wasn't billed for the product he didn't return. Likewise, Ms. Jackson testified that he was billed and never complained about any of the invoice charges until after he was terminated. Ms. Jackson also testified that although defendant claims Mr. Taylor engaged in the practice of giving away no-charge product during his career and advised his other colleagues to do the same, Callaway noted, as testified by Ms. Jackson on the record during trial, that Callaway has never had this issue with any other sales rep or manager. Likewise, defendant stated in his response brief filed yesterday that defendant personally observed Mr. Taylor using his sample account to outfit staff when Mr. Taylor was an outside sales rep. But what he does not argue or claim was that Mr. Taylor wasn't charged for the product. So maybe he did see Mr. Taylor give away product, but that still doesn't negate that Mr. Taylor was charged for the product that he gave away. Defendant also tries to muddy the waters by claiming that Callaway should have attempted to retrieve the product from staff themselves. However, the records submitted as evidence during the trial clearly showed the shorthand initials and notes defendant kept would have made the recovery of such sample product unreasonable and unlikely. Further, that is not Callaway's duty. As the outside sales rep's job is to collect and return any and all product that he or she isn't prepared to purchase. The other defenses that the defendant has raised outside of the claims related to the contract are, one, that the defendant, maybe he didn't order these things on his account, or maybe he didn't receive these things, or maybe that even the invoices he never received as well. But as Ms. Jackson testified during the trial about the ordering process, was that unless defendant gave someone else his credentials, no one else could have ordered the product on his account. And the defendant did testify that he ordered the sample product at the direction of Mr. Taylor. Ms. Jackson further testified that the defendant never contacted them to complain that he didn't order any of the product that was listed on his invoices. Ms. Jackson also testified that he never complained about not receiving any products, or that any products were properly, or that any of the products weren't properly delivered to their designated address, be it to him or someone in the field. Moreover, all of the invoices went to the same place, which is defendant's address, as testified by Mrs. Jackson. Defendant acknowledged looking at them and even trying to make a chart related to the products listed on the invoices. Ms. Jackson talked about the automated procedure for sending invoices electronically and how that had worked without issue, such that there was no evidence introduced at trial to dispute plaintiff's claim that defendant did in fact receive the invoices. Instead, it was simply insinuated by defendant's counsel in questioning and statements that maybe Mr. Smith did not receive the invoices. As previously discussed, the superseded argument with regards to the 2018 contract still doesn't negate the fact that there were no issues with the invoices and that the invoices from 2018 would still be captured by the 2019 contract because the invoices were not due in 2018. Those invoices were not due until December 31st, 2019. With regards to the waived arguments, while defendant initially claimed plaintiff never raised any objections to the party admission argument at trial, they now concede some arguments were made. Now they claim that their objections are not, that our objections were not argued thoroughly enough as they were, and that they were briefed more thoroughly than they were argued, and such that they should be barred. However, Georgia law only requires that the issue be raised. Thus, plaintiff's objections to the evidence being submitted under the guise of a party admission for reasons starting with whether or not Mr. Taylor was authorized to sufficiently raise the issue at trial. Defendant failed to cite any case law showing where the court stated that the issue was raised, but not argued thoroughly enough to be briefed in more detail in a motion for judgment notwithstanding the verdict. With regards to the 403 issue, the court did raise the issue during the trial, during the point in which the court returned from the bench. And after that, both parties responded to the 403 arguments, such that even that issue was raised to satisfy the notice requirement. Therefore, whatever arguments that it wasn't raised or brought up, or that they didn't have notice about the 403 B claim also fails. Do you want me to go ahead and talk about a new trial or wait, Your Honor?
Go ahead.
Okay. Pursuant to OCGA 5-5-21, the presiding judge may exercise a sound discretion in granting or refusing new trials in cases where the verdict may be decided strongly against the weight of the evidence, even though they may appear to be slight evidence in favor of the finding. These statutes afford the trial court broad discretion to sit as the 13th juror and weigh the evidence on a motion for new trial alleging these grounds. A trial court reviewing a motion for a new trial based on these grounds has a duty to exercise its discretion and weigh the evidence and consider the credibility of the witnesses. At worst, the admission of defendant's hearsay statements, as further argued by defendant's counsel to the jury over objection of the plaintiff, warrants a new trial because the information and the testimony of the defendant was prejudicial and material to the verdict in defendant's favor. Without defendant's testimony, there really was no evidence offered to show that there was any other basis for the defendant not having to pay the invoices. The arguments about the contracts not being applicable because they were in 2018, so all of the 2018 invoices being waived did not have any impact because, again, the invoices were not due until 2019, which would mean that those 2018 invoices were covered by the 2019 contract, as were the 2019 invoices covered by the 2019 contract, because he quit in 2019, which called all of the invoices to be due before they would have been due under normal circumstances. Second, the defendant never stated that he didn't receive any of the invoices. The defendant never stated that he did not receive the products, and he did not state that he did not order the products. Moreover, plaintiff's testimony shows that this product was ordered properly using Mr. Smith's credentials, that it was sent per the instructions on the orders that were made by Mr. Casey, and that the invoices were sent, and that there were never any issues or any complaints by defendant with regards to any of those three things. So all of the other defenses that defendant raised failed, except for the hearsay testimony that was allowed to be introduced in the case to the jury. But for those arguments, there is no legal defense such that even if the court feels like the they do fit within the hearsay exception of being a party admission. Our argument is that the evidence was too prejudicial and should not have been introduced. And so at the very least, the plaintiff is entitled to a new trial to be able to present so that the case can be heard without that prejudicial evidence. And then the jury can decide based on the actual evidence that can be, or either the testimony of Mr. Taylor, because he was available and did talk to the defendant, and they decided not to call him.
Is that it?
Yes, ma'am, that's it.
Okay. All right. Ms. Cresswell, will you be responding?
Yes, Your Honor, I will.
Okay. Go ahead.
If I could ask, Your Honor, I think you were going to do this, but could we have an indication of everyone that is appearing on the Zoom for the defense part? I will say that my client, the defendant, Casey Smith, is on the Zoom, and my partner, Nathan Chapman, is also on the Zoom.
Okay. Ms. Rogers, you want to introduce the other? Well, we know Ms. Jackson, and I think Ms. Shellen was identified during the trial as being from Invoices or something.
Yes, and then we also have Rebecca Hanovoice, and she is one of the general counsels at Callaway.
Okay. And then who is 619-279-3490?
That is me, Diana Shellen, Your Honor.
Okay. Did Ms. Shellen, Ms. Rogers, did I get the Ms. Shellen part right? She's with Callaway?
Yes, that is correct.
Yes, ma'am.
Okay. All right. If you'd like to proceed, Ms. Cresswell.
Yes, thank you, Your Honor. Being mindful of the court's time, I want to hit the highlights rather than state again what we've stated in our brief. Overall, the argument that plaintiff's counsel just gave does not appreciate who bears the burden in this case. Callaway is the plaintiff. Callaway had the burden of proof, and Callaway did not carry the burden of proof. With respect to, I'll start sort of where Ms. Rogers ended. With respect to all of what we've been kind of calling the other defenses, is what she referred to them as. Those aren't affirmative defenses. Those are arguments that the plaintiff failed to carry the burden of proof. This is a breach of contract claim, and the plaintiff didn't prove that Mr. Smith ordered the product. The plaintiff didn't prove that Mr. Smith received the product. In fact, the plaintiff admitted that I think about 50%, even the plaintiff doesn't believe Mr. Smith received. And so, Your Honor, the plaintiff failed to carry the burden that they had in many respects. But turning from that to what is the real issue and the only issue that the plaintiff preserved with respect to a potential judgment notwithstanding the verdict. And that is an argument that the court made an error in admitting evidence. And in turning to that one issue that really is what the motion turns on, the court followed the law. And I will say, Your Honor, that the JNOV
You might recall, I thought I wasn't happy about the law. And nevertheless recognized begrudgingly that there is no gold dome over my particular courthouse, which for you California folks means I'm not the legislature. Go ahead, Ms. Cresswell.
Yes, Your Honor, I certainly do recall that and saw it when I had the opportunity to look at the transcript. You certainly put us through our paces to make sure that the law said what we told you it said, which is that under either Section C or Section D of the party admission rule, the testimony was admissible. Your Honor, the JNOV standard is stringent for a reason. It makes sure that the court and the jurors and the parties don't waste time and expense unnecessarily. It's designed and set up to make our judicial system efficient and fair. And the purposes of the rule were carried out in this case. Now, with regard to the party admission rule, very briefly, Your Honor, under Section C, there is, we showed, even if we had to lay a foundation, we did, that Mr. Taylor had authority. Now, the plaintiff suggests that the authority is dependent solely on Mr. Smith's contract with Callaway, and that's not the case. Those contracts may define what Mr. Smith's authority is, but they don't define Mr. Taylor's authority. Mr. Taylor was a regional sales manager. That is undisputed. There is no proof that Mr. Taylor was prohibited by Callaway from exercising discretion as a regional sales manager. No proof. All of the proof shows that he not only had that authority, but he exercised it, and he did it over the course of Mr. Smith's employment. And even, Mr. Smith even observed that Mr. Taylor got the same direction when Mr. Smith was a demo day rep. So it was consistent that a regional sales manager had authority to give the direction that Mr. Taylor gave to Mr. Smith.
But all of that came, all of that came from the hearsay. Taylor never came into the court and said, yeah, I got the same advice.
It doesn't, Your
All
Honor.
of that came from your client.
It came from my client, but not all of it is hearsay. Certainly, Mr. Smith properly testified with no objection as to what he personally observed to be the practice at Callaway for a number of years. We also introduced evidence from both Mr. Smith and Callaway that after this discretion was exercised, as we say it was, there was no negative repercussion to Mr. Smith or to Mr. Taylor. Mr. Smith never reconciled his accounts. He got a raise, he got good performance reviews, and Callaway never said, hey, you don't get any of those things because Taylor wasn't authorized to let you not reconcile your sample account every year. That never happened. All of the evidence is consistent with Mr. Taylor having the authority to give Mr. Smith direction. But Your Honor, really, we don't have to win on Section C because Section D applies, and the plaintiff has made no meaningful argument and identified no evidence that would take us out of Section D. We don't have to prove authority, Your Honor. One of the cases that the plaintiff cited, the 11th Circuit case, it recognized that the advisory comment to the federal rule recognizes the breadth of this. You don't have to prove speaking authority under Section D. It's about scope of employment. It's about a statement being made in the course of employment and within the scope of employment, which this statement unquestionably was. There is no evidence to the contrary. It's undisputed. Mr. Taylor was a regional sales manager. It's undisputed that Mr. Smith was an outside sales representative who reported to him. It's undisputed that the statement that was made to Mr. Smith concerned the sales duties Mr. Smith was supposed to perform and the sales duties that Mr. Taylor was charged with supervising and directing Mr. Smith as to. There's no dispute about any of those facts. That puts us squarely within Emory Healthcare, which we discussed at trial, which has been discussed in the briefing, and which the plaintiff has responded to with one sentence, which does not make a meaningful distinction. It simply states what the facts of that case were. without providing any distinction from those facts and our facts. Both statements were made by an employee of a party within the scope of their employment. And what brings home that we fall within Emory Healthcare is a consideration of the case that the plaintiff principally relies on, Royal Oil. Your Honor, that case was about a cabin steward, a low-level employee, who the statement that he made was necessarily outside the scope of his employment. He was talking about a door in the pool area, and that was an area that he was not supposed to work in. That is completely different. So that low-level employee is precluded from working in the area that relates to his statement. That's not the case with Mr. Taylor. He is a regional sales manager who is charged with a duty to work in the area where he made the statement, to direct his subordinate, Mr. Smith, with regard to sales. And Your Honor, that brings me to a word that the plaintiff used, which was windfall, suggesting that Mr. Smith somehow got a windfall. That is completely incorrect, as the evidence showed. Mr. Smith used the sample product as directed by Mr. Taylor to promote the Callaway brand in his territory, and he did it really well. He doubled sales from 3 million to over 6 million. And Callaway accepted the benefit of that. If there would be a windfall to anybody, it would be a windfall to Callaway if they were able to keep the benefit of Mr. Smith's efforts at Mr. Taylor's direction, and now charge Mr. Smith for making them money and promoting their brand. That's what would be the windfall that would be inappropriate, Your Honor. One final note, Your Honor, about Rule 403. I think there was an argument that we had noticed that a 403 because the court mentioned it and because there was some argument about it. But this is a motion for judgment notwithstanding the verdict. There is an obligation on the part of the plaintiff to preserve whatever issues they believe underpin a J&OV motion at trial. They did not object to Mr. Smith's testimony based on Rule 403. They didn't ask the court to exclude that testimony under Rule 403. It did not happen, and they certainly did not include that as a ground for their motion for directed verdict when they originally made it at the close of the plaintiff's case, nor at the conclusion of the evidence. And so, Your Honor, we think you should disregard that argument altogether. And in closing, Your Honor,
before you get there, I just want to say on the record, in case anybody else is reading this in the future, the court's concern was always fairness, and it was the concept that you could try a case based on proffer, that you didn't have to bring the witnesses in and have them subject to cross-examination and the scrutiny of the jury. You taught me a lesson with regard to the provision that I came back here and furiously researched. I'll continue to state my position. I'm not sure what's going to happen here, and I probably won't have an answer for you right now, but I'll continue to state my trial lawyer's mantra, which is the jury gets to see the witness and the out-of-court declarant. And so that was where I was coming from. prior to the ruling. And that's just all I want anybody else reading this transcript to understand, is that we, the trial judges, face our fellow citizens and community who come down for jury service. And if it's going to end up looking like, you know, a 15-minute proffer, why couldn't they just stay home and watch it on TV? That's all. All right. Soapbox moment is over. Anything further, Ms. Cresswell?
Very briefly, just to speak to the fairness issue that Your Honor just mentioned.
Because I thought Taylor was going to walk in the back of the courtroom and we'd have a fair fight.
Your Honor, this was a fair trial, and I say that because the plaintiff had the opportunity to take Mr. Taylor's deposition or Mr. Smith's deposition. They didn't do either of those things. The plaintiff had the opportunity to bring Mr. Taylor to trial. They listed him as a trial witness. We didn't object to that. They just didn't bring him to the courtroom. The plaintiff has the burden of proof, and if they were on full notice of what Mr. Smith was going to say. We had a summary judgment motion fully briefed and heard. There was no secret about what Mr. Smith was going to say, which was that Mr. Taylor directed him to do it. Now, given that notice, it was entirely fair to expect that if the plaintiff thought that they needed Mr. Taylor to testify in order to rebut Mr. Smith's proper testimony, they should have subpoenaed him or gotten him voluntarily to come to the courtroom, and they didn't do those things. So, Your Honor, while we appreciate the court's dedication to making sure trials are fair, this one was. And Your Honor, if there are any questions that the court has that I haven't addressed, I would certainly be happy to address those now.
Okay. Any response to that, Ms. Rogers? And then I'm going to ask her to argue the attorney's fees.
Yes, only three quick things, Your Honor. With regard to the scope, again, it can't be within the scope of your employment if you're directly contradicting what the contract states. And the contract did not give Mr. Taylor the authority to make those discretionary determinations during the time that Mr. Taylor was employed. So any alleged statements were in fact outside of the scope of Mr. Taylor's authority. Moreover, the 403 issue that she says should be barred wasn't raised with regards to the motion for the JNOV, but for the motion for the new trial. That's where we raised the issue with regard to the statements being prejudicial and being the basis for which we should have a new trial. And lastly, Your Honor, defendant is correct. We did not call Mr. Taylor because, one, the defendant stated that they were going to call him for trial, and two, we didn't feel the need that there was going to be a need to rebut the hearsay testimony because it was hearsay, which we thought would not be admissible, and we still believe should not have been admissible. So there wasn't a need to call him to rebut inadmissible testimony.
Okay. Thank you very much. All right, Ms. Cresswell. Help me with one thing off the bat, and I read through the pleading certainly, but is it reasonable or is it actual?
With respect to 13-111, Your Honor, we would say that it is actual. To the extent the court views it as a reasonable standard, we have also met that.
Okay. How much you want? You want 100 and something, right?
It's Your Honor, it's in Mr. Chapman's affidavit, it's a little over 176,000 in fees and a little or almost 6,000 in expenses. That was through January 27th, Your Honor, and there have been some fees incurred since we filed Mr. Chapman's affidavit. He is on the Zoom and can provide testimony with respect to those additional fees, if Your Honor would permit. But I wanted to start just by asking, Judge, we've supplied you with Mr. Chapman's affidavit. I would assume, but I'll just ask, do you want us to put Mr. Chapman on to give the same testimony that is in his affidavit?
I don't need it, but I do believe that the law is that Ms. Rogers is entitled to cross him if she would like. Do you
Certainly.
intend to do that, Ms. Rogers?
I know that if we have the time, yes.
Well, let me say this, Ms. Cresswell. I think the appropriate, if he'll just affirm his affidavit, and I'm not putting you under oath, Mr. Chapman, you can state in your place. Anything you want to say, or Ms. Cresswell, is this the time?
Sure. Would you like us to do that and then argue, make the legal argument, or vice versa, Your Honor?
Okay.
All right. We'll start then with Mr. Chapman and let Ms. Rogers do whatever cross she'd like. Mr. Chapman, good morning.
Good morning.
I want to
Morning,
make
Honor.
sure.
Hey.
Want to make sure we could hear your voice, and we can. So, would you please affirm to the court that you filed originally an affidavit and then a supplemental affidavit yesterday that sets forth the total amount of attorney's fees and expenses incurred by Mr. Smith through January 22, I believe it was?
Yes, that is accurate, subject to all of the discounts and reductions that are contained in those bills. But yes, that is everything that was billed to Mr. Smith and that he is responsible for paying through January 27th at 5 p.m.
And I'll turn it over to you to let you state in your place with respect to what has been incurred since that time.
Yes, thank you, Ms. Cresswell. Your Honor, since we filed the original fee petition, we have received a response to that petition, which we have prepared a reply to address some of the purported deficiencies therein. We have also prepared a supplemental affidavit for me and the reply brief. Those tasks were performed between January 27th and today. We also had to review and respond to the JNOV motion, the original one, as there was work that was done on that, and then there was an amended one that we had to respond to in full. And so both of those are the primary tasks and the primary source of work that has been done since January 27th, 2022 at 5 p.m. Mr. Smith has been received 2 bills since then, one for January's work and one for February's work. Those invoices can be submitted to the court upon request, as well as the work in progress for the month of March, where the bulk of the work has been performed, given the filings that Callaway made at the end of February, namely the response to the attorney's fees petition and also to the motion, or also the amended motion for JNOV and new trial. Most of the work, as I said, was performed in March, and in terms of the amount of that work, I can tell you that between January 27th at 5 p.m. and today, excluding the time spent today at this hearing, we've expended 47.4 hours of Ms. Taryn Howman's time at $420 an hour. It's a total of $19,908. Preparing the response to the original and the amended JNOV motions, and 17 hours approximately reviewing the response to our fee petition and preparing a draft reply along with affidavits and supporting papers. Ms. Cresswell, in the time period between January 27th, 2022, and today, excluding this morning's proceedings, has incurred a total of 23.3 hours at a reduced rate of $575 per hour. This is the rate that we agreed to hold Mr. Smith's hold for Mr. Smith throughout the life of this matter. And she has incurred a total of $13,397.50. That's approximately 15 hours related to responding to the original and amended JNOV and new trial motions, as well as 8 hours related to the attorney's fees petition, and preparing strategy and drafting the reply and reviewing the reply brief in support of our fee petition. And for myself, I've spent approximately 7 hours, actually it's exactly 7 hours, for a total of about $4,025, reviewing and revising the petition for attorney's fees, my affidavit, the reply brief, and the supplemental affidavit was submitted. All told, that is just upwards of $37,000 that we've had to expend responding to not one but two JNOV motions and preparing our fee petition in this case. If there's any other information you'd like, happy to address that. And Ms. Cresswell, if you have any other questions for me, I'm happy to address those.
Mr. Chapman, how much is Mr. Smith paid?
Mr. Smith has paid approximately $99,000 to date. I believe it's right around there. And he is contractually bound to pay the rest to us through his engagement letter. So yes, he's paid us a little less than half, I think, what we would have outstanding right now. But yes, that's my understanding, Your Honor.
All right. Yeah, I mean, you asked whether Ms. Cresswell had other questions. I am going to let Ms. Rogers question him. Ms. Cresswell, is this a good time to do that, or did you have other questions?
It is, Your Honor. I just wanted to ask, are we to make it efficient? May we make Mr. Chapman's supplemental affidavit an exhibit to this hearing, to have it admitted as an exhibit so that it can be included with the transcript?
Sure. It's one that's already been recorded, filed, e-filed?
Yes, Your Honor.
Okay, so it's the supplemental affidavit. Let me make sure, and I'll print it now. Or you can print it. This is your court reporter, right?
No, Your Honor, it's the plaintiff's court reporter.
Okay. If you can get her email, you can just send it to her.
Sure, we'll be glad to do that, Your Honor. I have her email in the chat. We'll be glad to do that with the court's permission. We'll just make it defendant's exhibit 1 to this hearing.
And that's the one filed on March 14th?
Yes, Your Honor.
Okay. Okay. Ms. Rogers, any cross-examination or questions for Mr. Chapman?
Yes. Good morning, Mr. Chapman. How are you?
Good morning, Ms. Rogers. How are you?
I'm doing well. I only have a couple of quick questions for you. Are you aware of your firm providing discounts to any other clients?
Yes, we are.
Okay. And are you familiar with the rates of your California attorneys? And if so, can you outline those for us?
Yes, I set those rates. Which specific California attorneys are you referring to?
So in your briefs, you kind of provided a range for paralegals, associates of counsel, and partners. Could you do the same?
Sure. And it depends on the year that you're talking in. So do you have a specific question on year, or would you like me to just address it generally as of today?
We can do it as of 2021.
Sure. As of 2021, our standard rates for associates in California would have been between $450 and $550 an hour, so slightly higher than our Atlanta rates given that market. And our rates for partners would have been between $600 and $700 an hour. And again, it depends on the client. We have clients who do, significant volumes of business with us that get discounts. off those rates as well. So those are the standard rates, and then we would, depending on the client and the relationship, there might be discounts off of those rates in Los Angeles. But yes, the rates are higher in LA than they are in Atlanta, but not by a tremendous amount.
Okay. And I heard you refer to those discounts again. Is that, I guess normal standard practice?
No, it is not. We give discounts to very few clients. Typically, if they are doing a significant volume with us, we would give discounts, at 5% maybe. If they are, it really depends, but you do not see discounts very often higher than 5%. That's sort of our maximum, unless they are, really, really, guaranteeing a specific volume that would allow us to do a little bit more.
Okay, so for clients that give you significant volume of work, then the discount percent could be higher than 5%.
It could be, I will give you an example without saying the client's name, because I do want to maintain the confidentiality of that, but we only have one client that gets higher than 5%, and it is our biggest client that accounts for probably 60% of our firm's work.
Okay. And then do you have access to the invoices?
I can certainly pull it up if you'd like me to make reference to the affidavit and the invoices.
Yes, only two particular invoices, if you don't mind.
And
they weren't, I was about to say, they weren't page numbered, so I can maybe give you the invoice number. Yeah,
if you just tell me the date of the invoice, let me just pull them up. If you don't, is that okay if I refer to them?
Sure. So I believe it's the November 11th invoice and the November 29th invoice.
Sure. Just give me 1 second. Okay, I'm going to make reference to my supplemental affidavit dated 3/14/22.
Okay.
As soon as I can get it out here. There we go. And then I am looking at the invoice dated, let me pull it over here so I'm not looking sideways at the camera. Let's see, February 17th, 2021. You're asking me about the November 2020?
It should be November 2021. So,
okay, hold on, November.
18742.
Yes, 18742 is the first invoice number, and the other invoice number is 18886. So 3 8s and a 6.
Okay, and I'm looking at September. Sorry, I've just got to scroll down to it. I apologize for the time. November 11th, 2021.
Yes.
Okay, yes, I have it out. I'm looking at the very first page of that invoice.
Okay, so if you don't mind, I guess you're going to go probably a little more than midway down that first page of the invoice, and you'll see there are some no charges for Ms. Cresswell and Mrs. Hahnemann.
Howman, yes, that's correct.
I'm sorry.
As well as for myself.
Okay, I'm not sure. Maybe I oh, yep, yours as well for the meeting.
Mm-hmm. Yes, that's correct.
And then also on the subsequent page, so page 2 of that invoice.
Yes, that's correct.
Okay, and then it was your testimony that the defendant no charge the time, or that KCO no charge the time that they spent, that Ms. Creswell and I'm going to mispronounce it, Howman, spent getting up to speed on invoice 18742. Is that correct?
That is correct.
Okay. And then if you don't mind, I believe in the amended affidavit, you noted that the time, and in the brief, it was noted that the time that was waived and then recharged was because they were getting up to speed and preparing for trial. Is that correct?
No, I don't think anything was recharged, and I don't believe that I ever said that.
Okay. If we look at page 8 of the reply brief that was filed on yesterday,
Sure.
which I was gonna say you may or may not have up. And really, I guess it starts on page 7.
Mm-hmm.
At the last paragraph of page 7, it notes that plaintiff was critical of the no charge time. And we skip down to that last sentence on page 7. It says that Callaway ignores that all of the time entries on 1880, well, on 18886 included a review of documents for the specific purpose of preparing for trial and not to familiarize themselves with the case. Chapman affidavit exhibit G at pages 23 through 26.
Yeah.
Is that?
I mean, that's what the argument says. Yeah. I'm having a little difficulty following what you're saying. We no charge significant amount of time for them to review documents and get up to speed on the case. There were certain no charges. There were certain charges for, if you'll see on invoice, you look at the last page of the invoice you're referring to. Ms. Cresswell, we charged for some time that she spent planning trial themes and preparing witness examinations, voir dire, directed verdict motions, and some time that Ms. Howman spent drafting sample jury charges. So I'm not entirely sure what you're saying we did charge for in that regard, other than what's noted there.
Right. So what we noted in our response brief is that some of the notations that were no charge were then re-noted in the following brief and charged for. And in the response brief, the argument was that the second time it was charged, it was because it was preparing for trial. And I just wanted to make sure that I understood that argument correctly.
Yeah, that's, I would say that's, I don't agree with that on its face. The charges are not the same and the descriptions are not the same. They differ substantially between the first invoice you referenced and the second invoice, the November 29th invoice you referenced. And there are no overlaps as far as the dates. The last date on the first invoice is 10/29/21. The first date on the next invoice is 11/1/21. And there may be some overlap in some descriptions, the use of certain words like strategic planning. But other than that, I don't see any duplicative charges, nor would I have permitted a duplicative charge to be issued to my client.
Okay. And then the difference was that on the second invoice, it was in preparation for trial and when they were no charged, it was not in preparation for trial?
No, I think that there was certain work that was done preparing for trial that we no charged regardless, because we attributed, even though it was planning for trial, at some point we could not differentiate at that point, given their early involvement in this, between stuff that was purely getting up to speed and stuff that was, and I say stuff, I should say work that was purely getting up to speed versus work that was preparing for trial. You had a 4 or 5 day period where there was a lot of work performed that I did not feel was appropriate to charge Mr. Smith, because it could not be easily put into one bucket. It overlapped. So I gave him the benefit of the doubt and no charge that time, a significant amount of it. And then once they had kind of gotten past that ramp up period and started doing things that would any lawyer, including Mr. Sherman or myself, would have done to prepare for the trial, that's when we invoiced Mr. Smith for that time. because I felt that at that point in my, I try to do what's right by my clients, and I try to bill them fairly. And I believe that work was necessary and discreet and not repetitive. That's why those charges are on there as of 11/1.
Okay, no further questions. For me, I don't know if you have any follow-up, Ms. Cresswell, but those were all of my questions.
Thank you, Ms.
Cresswell,
Roberts.
I'm just trying, and Mr. Chapman said it was about 99. I'm just trying to figure out exactly how much Mr. Smith has paid.
Your Honor, I did want to ask a clarifying question along those lines,
Okay.
Mr. Chapman. Mr. Chapman, you said that Mr. Smith is contractually bound to pay the invoices that he has not yet paid. Could you elaborate on that and include in that any indication as to whether there is interest accruing on that amount?
Yes. So there are two contracts. I referenced the engagement letter, which we submitted, or I'm sorry, it was attached to Mr. Smith's affidavit that we originally submitted. The engagement letter sets forth the terms of our fees and provides that if there's invoices that are not timely paid, that those will accrue interest at a certain rate. I believe it's 1.5% a month. Mr. Smith has also signed a promissory note for the fees outstanding as of, I believe, early January. I'd have to check my records, but he has also agreed to pay the fees under a promissory note. So, and we would probably get another one for the balance. But I can tell you that as of today, as set forth in paragraph 29 of my supplemental affidavit, that he has paid a total of $99,931.48 to us, and has in fact promised to pay the outstanding and future fees that we've incurred, including those that I've described today.
Anything further, Ms. Cresswell?
And so, Your Honor, with regard to that last point, I want to go back to the first question that you asked me. In terms of the actual fees incurred, our position is that all of the fees incurred are actually incurred, including because they have been paid and because they're subject to a promissory note that obligates Mr. Smith to pay them. I just wanted to clarify that point, Your Honor.
All right. Anything further? Now, you said you had some, did you have argument?
I do, if Your Honor wants to hear it, but certainly, I think we set forth our position pretty well in the papers. I will note a couple of things Mr. Chapman said in his testimony. There was a reference to California rates versus Atlanta rates. And as Mr. Chapman testified, our Atlanta rates are set for the Atlanta market. They're lower than the California rate, and they're reasonable and they're market for Atlanta. So on that point, I wanted to emphasize that, Your Honor. There's no, the plaintiff hasn't pointed out any hours that were not expended on necessary work, or that were charged as a result of an hourly rate that was unreasonable. So we would ask the court to enter an award for the full amount of attorney's fees and expenses that we have requested, including the $37,000 that Mr. Chapman testified to today, in addition to the amounts that are set forth in his supplemental affidavit. So
You're asking for 210 roughly?
Roughly, Your Honor.
Okay, thank you. All right, Ms. Rogers, would you like to respond?
Yes, just a couple of quick highlights, and then one issue that I'd like to go in a little bit more deeply. So one, I know in the reply brief, defendant noted that the amount in issue was, I think, almost $200,000 or something close to that. But in their original motion at page 14, they noted, and we agreed, that when the case was filed and for for most of the case, the amount at issue was the $98,870.81. With regards to the duplicative charges, we did outline those. Even though today Mr. Chapman says that the work was in part done to get them up to speed, and some of it was in part done getting ready for trial, and that it was just all overlapped. And so he just waived some of it out of fairness to the client. That is not what they briefed. They briefed that what was done and waived in the November 11th invoice was for them to get up to speed, and that in the second invoice, they specifically noted in the reply brief that those things were done in preparation for trial. But as noted in our response brief, both charges say that they are doing those things with regards to trial, and those descriptions were the same in both invoices, one being waived and then again showing back up just days later as being charged. With regards to the California rates, again, in the reply brief, they did try to justify that they should be allowed to use our council's rates because they were California councils and they had an office in California. Now Mr. Chapman backtracks and says that, Ms. Creswell backtracks and they say that no, we're not using the California rates to justify our current rates, but in fact that our Atlanta rates are justifiable because our California rates are higher. So it's one or the other. But what we want to spend the most time focused on are the misstatements and why the court should use their discretion to, if not significantly reduce the award for attorney's fees, to not award any attorney's fees at all. And that is the misstatements that have been made throughout the trial to this court, either on the record in arguments and in briefs. And even after the receipt of the trial script, which they paid to have transcribed but never ordered, the defendant still making bold claims that are easily contradicted by the record. On page 8 of the defendant's brief filed late yesterday afternoon, defendant boldly asserts, and I quote, "After hearing arguments from counsel regarding plaintiff's motion for a directed verdict, the court retired to chambers to conduct independent research on the hearsay issue after instructing counsel to do the same," end quote, properly citing the transcript record. However, the court did not instruct the parties to conduct research on the hearsay issue. Specifically and immediately after defendant's counsel finished speaking, Your Honor said, and I quote, "Well, I'm going to take some time off the bench for a minute. I will be back." Nothing less, nothing more. Further, defendant also claimed that the court was encouraging settlement only related to the issues of attorney's fees, when Your Honor raised settlement before attorney's fees were even an issue after returning from chambers, but before bringing the jury back in. And that can be seen at trial transcript page 176 from the November 29th, 21 transcript. They also continue to claim that plaintiff ignored the court's instructions. In the reply brief that they filed on yesterday, they said the court ignored any instructions about the court to file any petition for fees by January 28, 22, when plaintiff plainly and expressly stated on page 3 of their response brief and in paragraph 2 that plaintiff acknowledges that defendant's counsel did seek a deadline from the court to file a motion for attorney's fees and was instructed to do so by the court to file its fee petition by January 28, 2022. So the assertion that we ignored the court's instruction is just a complete misstatement of the record and of the facts. They also claim that plaintiff completely ignores the fact that KCO provided a significant courtesy discount to Mr. Smith. And again, our response brief on page 10 has an entire paragraph discussing the courtesy discount that they provided. Such mischaracterizations of the fact are a pattern with the defendant. And while defendant claims that it is Callaway making false ad hominem attacks, the record is clear that defendant and the defendant's counsels are the ones who continuously misrepresent the facts to this court. When caught making these strong, inaccurate statements, defendant counsel weighs off the mischaracterizations, for example, that they didn't choose to address in their reply brief as mistakes. In page 9 of the brief filed yesterday, afternoon, they claimed that they simply didn't recall plaintiff making any arguments regarding the admission rule with regards to whether or not Mr. Taylor had authority, but now acknowledged that he did. Likewise, in the reply brief to the motion for attorney's fees, they also claimed that they just accidentally left off pages of the invoice and that they accidentally left the hotel costs inside of the invoice, inside of the invoices. Such bold mischaracterizations of fact, especially in their file briefs, their own invoices and trial transcripts, should not be rewarded by this court. Acknowledging, as we did in our response brief, that although the case law cited is not controlling, it is recent and it is showing a new trend in which the courts do have the ability to drastically reduce attorneys' fees and even award no attorney's fees when the prevailing party's behavior is undesirable. Defendant argues that the cases cited shouldn't apply because the courts were dealing with plaintiff's request for attorney's fees, but that doesn't deal with the underlying holding in the cases. The decision was not based on whether or not the requesting party was a plaintiff, or nor what type of case it was. It was based on the principle that courts do not want to reward bad behavior. And in this case, we think that you should do the same and not reward bad behavior with such blatant misrepresentations of the fact and of the record.
Okay, thank you. Does anyone, and I'll give you a chance to respond if you have to, but does anyone, and I will ask this question, I'm not asking you to, I think it is an appropriate inquiry by the court on 13-6-11, certainly on 9-15-14, and we don't have that at all, thank heavens. But I don't know that it's beyond the authority of the court to invite you, if you would like, to tell me the last settlement offer.
Your Honor, we do not think it's appropriate because neither of those statutes, this is a contractual prevailing party attorney's fee provision. Settlement discussions have gone on in a confidential context, in an effort to compromise, and we think it would be inappropriate to reveal confidential communications because those negotiations took place before a lot of things happened in this case, Your Honor.
Your Honor,
I began, go ahead, Ms. Rogers.
I was going to say we disagree because in both the original motion for attorney's fees and the supporting reply brief for attorney's fees, they go on and on about the fact that we did not and refused to engage in settlement discussions, which we have also rebutted with facts on from the record that we in fact did, and that we really did try and make good efforts to settle this case. So we don't have an issue with discussing what the last settlement.
Okay, well, I don't want to make this any cloudier than it already is. It's under 13.1 or 13.11.1. What is it, Ms. Kressel?
13.111, Your Honor.
13.111. You're the one that said it might be reasonable, Ms. Kressel.
It is reasonable attorney's fees, but Your Honor, I also, in response to your question, under 13.111, it's a contractual obligation that the plaintiff pay the attorney's fees incurred, which are actual attorney's fees. And I said, we also proved that the fees are reasonable. They're reasonable and customary for this market. We showed you the number of hours, we showed you the hourly rates, and that all of those were necessarily and reasonably incurred and charged and will be paid.
How do I get to that question without knowing that you had to go to trial? Of course, you're the defendants. I mean, you're the defendant, so that's.
Your Honor, reasonableness does not take into account whether we had to go to trial. Reasonableness takes into account whether it was necessary to expend the fees in order to defend the case. And we did. What Your Honor is suggesting is what fees would have been incurred if we had chosen not to defend the case and compromise, and Mr. Smith had paid money to the plaintiff that the jury found he was not obligated to pay. That's an entirely separate analysis, and it does not bear on whether our fees are reasonable and customary for defending the case, or whether they were reasonably incurred or actually incurred as the prevailing party in this case, which they were.
Well, let's assume for the sake of argument, since you lawyers have told me that it's true that he's paid $100,000 in fees, and the original amount in controversy was what, 60?
No, it was 67 and change plus attorney's fees plus interest, which is what we, I mean,
You don't think the court can consider that he spent 3 times, or he's incurred 3 times the amount in controversy and fees?
No, Your Honor, I don't think that. I think Your Honor has to decide whether the hourly rate is reasonable for the market, and whether the hours that were expended were reasonably expended to do the tasks that we did to defend and to be the prevailing party. That is the analysis. It's not what would we have spent to try to settle the case and not clear Mr. Smith's name, not defend against the charges that were made against him, which essentially amounted to that Callaway accused him of stealing. So that is not the analysis. He is entitled under the contract to the fees he incurred to be the prevailing party, and that's what we're asking the court to award.
Okay, I'm not going to cloud this record anymore by insisting on knowing that, because frankly, I'm going to go ahead and make my decision based on, I guess I'll use that pesky old law again. But I do want to tell everybody before we finish that it's good to see everybody. Enjoyed this case. I think the jury was congenial. I hope y'all, and it didn't come up today, and I'm so glad that it didn't, but I hope y'all all got an opportunity to spend time with the jurors afterwards, because they were anxious to talk. And, it was it wasn't by any means our first, but it was good. So good to have them in the building and see everybody back and get to see people in person. So, settlement doesn't have to be over right this second. And I'm sure that y'all have reached out to each other. And if you haven't, I'm probably not going to decide this case before the end of the week, but I am going to decide it pretty quickly. So it's good to see everybody. I hope everybody's continuing to do well. And I'm now going to take us off YouTube.
Your Honor?
Uh-huh.
I didn't get a chance. The last argument that Ms. Rogers
Let
made,
me shut my. What, Ms. Creswell?
I'm sorry, Your Honor, just very briefly.
Oh, is there more fight in you? I thought you'd finished.
Well, Your Honor, for the record, the last argument that was made accused my firm and me of a pattern of mischaracterization. And I just want to put on the record that, of course we disagree with that, and we'll stand on the record, but none of that occurred. The only ad hominem attacks were against us, not made by us.
Okay.